And just so we can be organized, I'd like to remind everybody in the committee that I prefer when people talk that they use their little request to speak thing, because I can't see very well. Okay? And I will make sure everybody who wants to speak gets to speak. So I'm also going to handle motions that way. So if somebody wants to, so when we get to the regular docket, and someone wants to do a motion, and then they want to second, they've got to push their buttons. Okay? So, and Danielle, why don't you come on up here? Okay, so let's start with the Civil Subcommittee uncontested docket.
Thank you, Mr. Chairman. I think we have 16 bills coming out of the Civil Sub. A bunch of them have line amendments and substitutes. All of those are in a stack beside you, so I encourage everybody to go ahead and take a look at those. If the chair would like, I'll move adoption of those at the end of presenting the bills, as opposed to them individually. So the first bill we had is Senate Bill 815. This prioritizes debts in the decedent's estate and raises unpaid child support up the list of the hierarchy of unpaid debts. Senate Bill 860, I note that was from Senator Surville, kind of a first for this committee. Senate Bill 867 is lien against person whose negligence causes injury and just clarifies emergency medical services agencies can collect the lien in addition to the emergency medical service provider. Senate Bill 873 from Senator Marsden gives fire chiefs authority for unmanned aircraft systems at a fire or in the immediate airspace above a fire or an emergency. We actually removed a line amendment which would have directed new regulations regarding use of unmanned systems. Senate Bill 913 comes from the Wills Trust and Estate section from Senator Edwards. It codifies the Uniform Trust Decanting Act. Don't ask me what it means. Senate Bill 927 from Senator Peterson addresses the timing for initiation of quick take condemnation procedures and petitions for determination of just compensation. Senate Bill 946 from Senator Obenshain, I think this came from the Supreme Court, expresses the time for noting appeals in days rather than months. Senate Bill 947 is a related bill, petition for appeal, time period for which the petition must be presented, also changes that months into days. Senate Bill 1024 is Senator Dunneman's bill regarding healthcare practitioners reporting disabilities of drivers. I think with the amendments we're going to adopt, this conforms it to a House bill we had earlier this session. Senate Bill 1060 is Senator Black's female genital mutilation bill. This is the bill that had a criminal section, created a criminal violation, a Class 1 misdemeanor. I think it reported out of Crim Sub unanimously. It was sent to us in civil to look at the civil provision. We made it consistent with the way we've handled other civil actions arising out of criminal acts and recommend reporting that unanimously. Senate Bill 1153 is identical to a bill that was passed last year. This is Senator Obenshain's bill regarding inverse condemnation proceedings and makes it clear that an owner can be reimbursed for their costs for damage, not just a taking. Senate Bill 1189. BML, VACO, Mr. Dix, everybody else on board. This involves water and sewer services and the liens and when the property owner can be responsible for a lien incurred by the tenant. We've seen bills related to this for several years now. Senate Bill 1342, also from Senator Surville, provides that the jurisdictional limit in general report does not include attorney's fees. Senate Bill 1343, also from Senator Surville, was in regards to reimbursement for costs of guardian ad litem. We had some line amendments to make it clear that DSS or Child Welfare did not have to pay those costs. Senate Bill 1360 from Senator Reeves regarding Civil Actions Department of Military Affairs. This allows certain employees of the department to prepare, execute, and file certain documents without having intervention of a lawyer. This can hopefully allow them to collect some outstanding money. Senate Bill 1421 from Senator Mason was in regards to interest on amount of awards in a condemnation proceeding. And Senate Bill 1459 came from the Treasurer Association, carried by Senator Edwards. This is in regards to discharge of treasurers. A discharge is not a firing of a treasurer. It's how you discharge the treasurer's duties upon retirement or death. And in this case, it just allows the local attorney, the county attorney, to be involved in that. Mr. Chairman, those are all the bills. Again, the line amendments and substitutes are before everybody, and I'll move adoption of all line amendments and substitutes in a block.
So,
Chair,
yes, Billy?
this will delight Delegate Habib, but the criminal guys might need to take another look at language that came out of our subcommittee on the mutilation bill. It's not anything that the civil guys did, but there's, one of our members has brought up something that we thought was in there that we don't see. So we'd ask that to be pulled out of the block.
So could we adopt, substitute that, and then take it out of the block and we get ready to vote?
So what we'll do is, let's first, the motion is to adopt all the amendments and substitutes. So is there a second?
Second.
Seconded, enthusiastic second.
Yes.
Yes.
Even though it violates the Servell rule.
Right. Okay, so all those who want to adopt the amendments and substitutes say aye.
Aye.
All opposed?
And then,
Okay, there's been a request to remove 1060 out of the block.
so Mr. Chairman, with that out of the block, that leaves us 15 bills that I think are currently on the board, and I would move we report those 15 bills in a block.
Okay, second.
We have some people in federal laws in the Senate. You guys have, who sits next to you usually? Morris. Morris, he might be, he's over there.
Fine.
Fairness is the same. Okay, well, they can just, I guess they go, just vote when they get here. Okay, so, motion then is to report the bills in the remaining in the block. Is there a second?
Second.
There's a second to vote the bills in the block. All those who want to vote on these bills indicate your vote on the electronic voting board. Okay, close the roll. All right, your report's 19-0. Okay, Delegate Bell, let's do criminal.
Sure, we can do the criminal uncontested, I think. Mr. Chair, I'm going to go through them. Senate Bill 817, Servell, involving restricted driver's licenses and purposes is for allowing in certain circumstances to use a restricted license to drive to a job interview. Stanley, Senate Bill 854, now looks like the Lufthansa bill, the intention is to send those to conference and then take the best ideas of both. I was trying to pre-conference, but it doesn't look like it's going to come together. SB 1008, Senator Hanger, this is to put all of the barrier crimes in one place, to consolidate the list, to add some crimes that have been left off, just because they're new or just were left off. Senate Bill 1054, Stewart, fire alarms, this is now identical to the House bill, whose number is escaping me, Mr. Cotter. 1404. Senate Bill 1091, Delegate Eben, driver's license after possession of marijuana charge. This is now identical to the Les Adams bill that passed through here previously. Senate Bill 1172, Senator Dance. This is now identical to what, Mr. Cotter? There's a House bill. 1931, Delegate Carr that passed previously. SB 1276, McDougal. This would add a few additional charges to those that could be addressed by proof of compliance in court. Senate Bill 1284, Obenchain, court order restitution form order. This is now identical to my bill that passed here. Senate Bill 1330, Carrico. This involves the composition and makeup of critical incident stress management teams. Senate Bill 1501, Senator Favola dealing with perks. Mr. Chair, all of those were reported out of the subcommittee unanimously. I would move all of the amendments and substitutes.
Okay. Motion to, in a second to adopt all the amendments and substitutes. All those in favor say aye. Aye. All opposed?
And Mr. Chair, I would move that we report all of those bills.
Okay. Right. All those who want to vote on these bills indicate your vote on electronic voting board. Okay, close the roll.
Mr. Chair, I yield to the floor.
Okay. Ready? Did we do it already? Okay, the bills report. Okay, Delegate Klein, let's do your mental health here. It's not here. Okay.
Mr. Bell, Mr. Chair, I'm not sure what role I have on that subcommittee, but I have some role I would like to make the report, if that's okay. All right, so these are the mental health report, please.
Okay.
Mr. Chair, we have Senate Bill 935, which is identical to House Bill 2462 that we came out of this body unanimously. And Senate Bill 1006, it's identical to our House Bill 1551, which also came out of this body unanimously, although out of a different committee. So I apologize, there's one person who voted against that on the floor, probably by error. In any case, it was the unanimous recommendation to the Mental Health Subcommittee to report both measures. I would move to substitutes and amendments.
Move substitutes amendments, is there a second?
Okay. Fairly good. Is it all we move?
That's the most successful motion you ever made.
Okay. And now I would move to report these two bills that the subcommittee endorsed unanimously.
All those who want to vote on these bills indicate your vote electronic voting board. Okay, close the roll. Forbes. And I think what we better do is we better wait for our friends who are in general laws. So we're going to stand at ease.
All right. Mr. Chair, we got a couple more crim ones we can do that I don't think have any controversy. The other ones were.
We're uneasy and back at stress.
Okay, I'm stressed, Mr. Chair. I'd ask the Senate Bill 1594. This was not unanimous, but the one person who made it not unanimous has said he's not quite sure why he voted that way and now is going to support it. So it's in effect a unanimous bill, and it involves investigators employed by the Attorney for the Commonwealth in their training. I therefore recommend reporting. I'm sorry, we need to substitute. I would ask that we adopt the substitute.
Okay, move to substitute, is there a second? Second. All those in favor of adopting the substitute say aye. Aye. All opposed, substitute is adopted.
Mr. Chair, I now would move the substitute.
Motion to adopt the substitute.
Second.
Okay. All those who want to vote on this bill indicate your vote electronic voting board. Okay, close the roll. I did. There we go. Okay, thank you. All right, close the roll. Reports 20 to 0.
Mr. Chair.
Any other no-brainers?
Yes.
Okay.
I would ask we take up 1564. This is Senator Norman's. Mr. Chair, this is now a subset of House Bill 2327, which was the Birchfield fix for DUIs. So the language as it is now is consistent with the language we've already reported. And so I will move. Do I need to amend it, Mr. Connor?
Mr. Chairman, the language in Senator Norman's bill that came over to us is identical to what was in the Birchfield bill as passed the Senate. So you leave it alone if you want to make sure they're identical.
I would ask Delegate Collins if he's going to accept the Senate amendments, because if so, that's what we want to do.
Mr. Chairman, I will accept the Senate amendments.
Okay, so to keep this consistent with what he's going to do, we need to reject our amendments, go back to the way it came over. Do we need to do anything? I understand. Okay, so Mr. Chair, I do not make any amendments to that. I would ask that we report Senate Bill 1564.
So now I'm confused. What is the bill going to look like?
So all this does is it gives priority for DUI search warrants. That is one small sentence of the longer Birchfield fix that Collins has, that is now consistent with it.
Mr. Chairman,
Yeah, please do.
I can kind of explain it real quick. So basically what we did was give priority to DUIs so that they would get in front of the pack. But the concern was that we would have someone that was facing life or limb. For example, they were watching a house where a murderer was. They wanted to get the arrest warrant before the guy fled the house. So we gave that authority to the magistrate to kind of make that decision. I felt comfortable with that kind of language. I think it's more important to get a murderer than or protect someone from an abuser rather than whether or not somebody needs to go to the hospital to get a blood draw.
So does our Birchfield bill have this priority thing in it?
It does. Our Birchfield bill that we put out gave priorities to the people looking for the blood.
Right.
And this new language, which is fine, still gives it priority, but that it kind of gives it to the magistrate if there's life and limb. And it depends on whose life or whose limb, I guess, but.
Right. Okay, so it's a subset of what we did. So there's a motion on the bill. Is there a second? Second. Moved and seconded to adopt. All those who want to vote this bill indicate your vote with electronic voting. All right, close the roll. Reports 20 to 0.
Mr. Chair, I got one more.
Okay, one more.
All right, so Senate Bill 1285. we would first off adopt the committee substitute.
Okay, move to substitute, is there a second? Right, all those in favor of adopting the substitute say aye. Aye. All opposed, substitute's adopted, Delegate Bell.
Yes, Mr. Chair, this is the bill that says that before someone's released from supervised probation, it has to be brought back for the judge. He has to be informed if they haven't finished the restitution. Now, just to make sure everybody votes the way they want to vote, nobody on this panel voted against my bill, because I'm charming apparently. But when the Obenshain bill came over, it had 4 no votes in Crim Sub. So if you wish to be consistent with your vote on my bill when it came through, you need to vote yes. If Elba Watts, Herring, or Mullen want to vote the same way they did in Crim Sub, they should vote no. But it is now the same bill. So, Mr. Chair, I would move that we report the amended bill.
Okay, 1285. I don't want to do that with these 2 guys.
I'm saying you voted yes already.
I voted for them. Right. I refused to be excused.
Starting for negotiations.
Right, all those want to vote in this bill indicate your vote in electronic voting board. All right. Close the roll. Reports.
Mr. Chair, we have one more that's a technical matter. I'd ask us to take up Senate Bill 1068.
Senate Bill 1068, we're doing 1068.
Mr. Chair, I'd ask, this actually reported 10-0, but staff identified a technical amendment we need to take up before we pass it out. I'd ask staff to report the technical amendment.
Mr. Chairman, this technical amendment is on line 17. After stricken or new comma, we have to insert a new or.
Mr. Chair, I would move the amendment.
Second. All those for the amendment say aye. Aye. All opposed. Okay. Adopted.
Mr. Chair, I would move we report the bill. Report it out of Crim, 10-0.
Why don't you take it with
Class 1 misdemeanor for a person without paying for it with the intent to cheat or defraud the owner or keeper to use a ski lift without a valid lift ticket or ski pass.
All right. This makes, there's a list. It's not illegal to steal services, okay? Unless there's a specific statute on point, and there's about defrauding an innkeeper and something like this. This adds to the list of things, services you can't steal using a ski lift pass. Okay? My dad used to make me walk. Right.
Not the first time, but I like it.
Okay, does anybody need to see this bill in writing? Remember, okay, so we can vote on this thing, and I think we need bill books. Okay, so yeah, we need bill books for all these testings. Okay, so let's vote on this bill. All those who want to vote this bill indicate your vote electronic voting board. All right. Close the roll. Reports 18-1. Okay, so I need, for contested bills, I need the bills again. Okay, so let's just get remaining contested bills. So, well, we need the bills for them too. we're gonna do the easy civil ones, and then we will get, so, we need copies of the following bills for Crim, okay? So, Jenica, can you write these down? Yeah, they got Ryan. Hey, guys, can you write these bills down, we'll get copies for everybody? Are you ready? Okay, Senate Bill 861, Senate Bill 865, Senate Bill 1257, Senate Bill 1347. Okay, and Delegate Habib, on your contested civil, which ones are ones that people are going to talk about and want to
None.
read?
They're all easy.
They're all easy?
Yeah.
Okay, so we don't need those. Probably need Senate Bill 1222 for Barkers. And I think that's all we need. Yes.
Mr. Chair,
Okay, Delegate Bell.
my understanding is Senate Bill 1222 from Senator Barker, who is sitting before us, was a bill that Delegate Klein's subcommittee heard. And staff has reminded us that we tabled the matter and asked it to be sent to the Deeds Commission. And staff's probably spoken to Senator Barker, and that's not
Senator Barker, do you want to try to get the bill passed today, or do you like to go to
No,
whatever you want to do?
Well, let me just very briefly explain sort of what's happened, and then I'd be happy to have the bill stricken. I don't think we need to proceed directly through the legislative process the rest of the way. I've worked with the administration, with the Department of Behavioral Health, with the hospitals, and with the CSBs, and we've come up with a way to implement this registry in a very low-cost manner that's estimated about $15,000 to $20,000, maybe slightly more than that in the end, but it can be absorbed into the current budget. Which actually was the language we put in the Senate budget, and so therefore we don't have to go through the entire process here. The magic is that what we've done is we've set it up as it's a voluntary thing, so the CSBs can use it or not use it. They would use it only when they can't immediately find what the bill said when we reported out of the Senate. It's only not in every case. It's only when they can't find a placement quickly, and they provide enough information that you don't trigger all the requirements to meet HIPAA. So there's not specifically case identifying information in there, but there's enough for the hospitals to say, yes, this is somebody we might be able to serve, or no, this is somebody we want to rule out. And if they say it's somebody we might be able to serve, they won't know categorically in every case that they will be able to, but they will then contact the CSB that has that person and be able to make a determination fairly quickly. And with all that, it will avoid nearly all of the expense. A lot of which is really set up around the mechanism of having every information on everybody and having to deal with all the HIPAA regulations, so that all the cybersecurity things that were put in place. So actually, it's been a very collaborative process thus far, and I think we're ready to move forward with it. And given that this is the last week of the legislative session, rather than try to get everything perfect in the language to do that, I'd say let's just let us go forward, and I'd be happy to have the bill stricken.
Senator Barker makes her favorite motion. You make a motion for him. Okay, is there a second? Okay, moved and seconded to strike the bill. All those in favor say aye. Aye. All opposed? Okay. And does this require me to send a letter to the Deeds Commission?
No, I don't think it, well, I mean, you can still send a letter to the Deeds Commission if you want, but I think what's, right now, I've been working with both the hospitals and with the administration, and to some extent with the CSBs, and the intent is to try to get this up and operating without having to do legislation or anything else. So you can have the Deeds Commission send a letter to the Deeds Commission, sort of have monitor the situation.
Okay, Delegate Bell.
Chair, you're already sending one for the House version. I just asked you to add literally
Right.
5 words. Senate Bill 1222 by Senator Barker to that letter, so it's coming
Okay, we're
over.
going to put that on my homework assignment, right? Okay, we got it done. Thank you, Senator.
Thank you. I'll be happy to come back out anytime you want to move quickly on things. Thank you.
Okay, and so let's go to Delegate Habib. You said you can do these without having.
Yes, sir, Mr. Chairman. The first bill we have, which is the female genital mutilation bill from Senator Black, was taken out of the block. I think the question has been answered. I've asked that we bring up Senate Bill 1060. We've already adopted the substitute, and I think that should be a unanimous vote, which I'd move to report. Senate Bill 1060.
Mr. Chair,
Delegate Bell.
it's very important that the last subcommittee to look at this was the Civil Laws Subcommittee, so we are happy to endorse their good work, and when it goes to the floor, it can be a Civil Subcommittee report. Thank you.
Mr. Chairman, I'm gonna defer to the gentleman from Albemarle on the floor.
You can try.
Explain this bill.
You can try.
All right, so motion is to report as amended. It's already been amended, so there's a second. Moved and second. All those want to vote in this bill, indicate your vote, electronic voting board. Over here. All right, close the roll. Report 20-0. Okay.
All right, Mr. Chairman, the next bill out of Civil Sub is Senator Peterson's 928. This is on a contested docket, but was a 7-2 vote. There is currently a prohibition in the law for sub-judges to be appointed in courts where they, quote, regularly practice. With some exceptions, this simply changes that presumption, and now it says the chief district shall, whenever possible, select a judge who does not regularly practice law in the court requiring a sub. This eliminates the scenario where you're unable to find a sub-judge familiar with that particular court. We had a bill earlier in the session from Delegate Miyares dealing with the Virginia Beach concern because they felt like their sub-judges weren't adequately prepared to appear in the courts they were appearing in because of this existing law which prohibited you from appearing in a court where you regularly practice. Again, this changes that presumption. It says the district court shall, whenever possible, select a judge who doesn't appear there but doesn't prohibit them from doing so. So the motion was 7-2 out of Civil Sub, and I would so move.
Okay. Dave Albo needs to look at this for a second.
If you want to spend some more time on that one, we can jump to the others if you'd like.
Let's skip that one for now.
Okay. Mr. Chairman, our next bill is Senate Bill 1210. There is a substitute that I'll move in just a moment. A couple of years ago, we created a criminal violation for creating a videographic or still image of a non-consenting individual who is nude, clad in undergarments or state of undress, and also someone who shares such images that they have received and maliciously disseminates them. The only thing this does is creates a parallel civil cause of action. The language in this bill sort of mirrors what we just did on Senator Black's bill where we created a civil cause of action. It also mirrors what we did with the human trafficking statute. There are 3 statute of limitations provisions in here that should provide opportunities for a plaintiff agreed by this to bring her or his claim. I think the only reason this is on the contested docket is because we had an abstention. So the vote was 8-0 to 1 to report Senate Bill 1210, and I would so move.
All right, 1210. We need to adopt a substitute first.
Yes, sir, we need to adopt the substitute.
So all those want to adopt the substitute say aye.
Aye.
All opposed? Substitute's adopted.
And I would move to report.
Okay, moving to adopt the substitute to report the bill. Steve, give it to me. All those want to vote this bill, indicate your vote, electronic voting board. Okay, close the roll. 20-0.
All right, Mr. Chairman, our next bill is Senate Bill 1413. This is Senator Sturtevant's anti-SLAPP bill. We've seen Chairman Kilgore's anti-SLAPP bill. Let me see if I can report accurately where we are right now. The House sent Chairman Kilgore's version to the Senate and included the language products, goods, or services as protected speech under anti-SLAPP. Senator Sturtevant's Senate bill came over here with the products, goods, and services language stripped out, and it was just third-party communications of things before a public body. The Senate is amending Kilgore's bill to take that language out. We have amended Kilgore's bill to put that language back in. Senator Sturtevant has indicated that he'll reject the amendment and put this into conference, and then we get to just that simple question of do we have goods, products, and services. So with me being the only vote against it, we substituted Kilgore's bill onto Sturtevant's bill. So the bill before us today is in the original form with good products and services in it, which is what I think the patrons would like ultimately to come out of conference, and which very well may come out of conference. I voted no for the reasons I've stated before about equating goods, products, and services with the First Amendment speech, but the subcommittee adopted that substitute and then recommended reporting, so I would move that we adopt the substitute which conforms Senator Sturtevant's bill to Chairman Kilgore's bill when it left the House.
Okay, and Delegate Kilgore, I'm assuming that you think that's a good idea, right? Okay. So it's been moved and seconded to amend the bill to look like Kilgore's. All of those in favor say aye.
Aye.
All opposed? Okay, Senator, you need a,
Mr. Chairman, that was 100% accurate, and appreciate the committee's time.
And Mr. Chairman, again, I'm a no vote on this, so I think Chairman Kilgore would move to report
yes.
this bill with the substitute.
Okay, is there a second?
Second Kilgore's motion.
Okay, and all those who want to vote this bill indicate your vote electronic voting board. Okay, close the roll. Reports 10 to 4.
Oh, yeah.
Thank you, Mr. Chairman. None of that one. Okay.
Mr. Chairman, our last bill, which I think is also easy because it was unanimous, it just had some substitute work that had to be done. As you remember, when the Birchfield bill came through, there was a civil provision and a criminal provision. Senator Norman had a small part of the criminal provision as a standalone bill. This is Senator Survell's civil bill that picks up the language that was in the more omnibus bill that we passed out. There is a substitute, which once we adopt, will conform it to the language of Delegate Collins' bill that came out of here, and I think that vote will then be unanimous. So I would move that we adopt the substitute that is before the committee.
Yeah, move to adopt the substitute. All those want to adopt the substitute, say aye. Aye.
All right, and then, Mr. Chairman, with that substitute adopted, again, this is just the standalone civil portion of what we've already seen in Delegate Collins' bill, and I would move that we report Senate Bill 1498 as substituted.
Second.
Okay, so, Senator, Senator, can you tell us what your bill does?
This makes it, well, after Birchfield, I think, and after the law we passed this year, I think all blood tests are probably going to be by search warrant. This just makes clear that if blood's tested pursuant to a search warrant, you get those same presumptions you get if it's a breath test in civil court.
Okay, that's a subset of your bill, Delegate Collins, right?
Mr. Chairman, it is. Also in our bill, we struck out some of the, you have to know you're drunk to be drunk to have the punitive damages section. So I think it all comports together.
It creates a rebuttable presumption that if you drank and got in a car, you knew you were going to be drunk when you put the beer in your mouth.
Right.
Okay, so yours includes that portion too?
Yes.
2 parts. Okay.
Good bill.
Any questions, members of the committee?
Good, tough on crime bill from
Any
Cyril.
members of the audience? For or against the bill? Okay, is there a motion on
Mr. Chairman, as I move the report, I would just indicate that Senator Survell got 4 of his 5 bills out of the Civil Subcommittee, and he has used up his next 4 years' worth of bills.
All right.
Move the report.
Report, is there a second? Second. All those who want to vote this bill indicate your vote electronic voting board. Okay. Right, close the roll.
And so,
It's 21 to 0.
Mr. Chairman, with the exception of Senate Bill 928 that you want to take a closer look at, that's all the Civil Sub has.
So let's go back to 928. I still don't understand what this does.
Sure. So, Mr. Chairman, the current law says that the chief judge can't appoint someone who, quote, regularly practices in a court to serve as a sub-judge. We have found that that is a barrier to getting sub-judges in courts that are versed in what that court actually does. And so what this bill says is, instead of prohibiting a chief district court judge from appointing somebody, they shall appoint whenever possible a sub-judge that does not regularly practice in that court, but does not prohibit them from doing so. This gives the chief judge making the appointment the flexibility to appoint the best person and doesn't preclude them just because they happen to appear in that court.
Okay, so, Senator, so this language here on line 21 says, when reasonably necessary, the chief district judge may designate a substitute judge from another district. I guess I don't understand what when reasonably necessary means.
Okay, I guess I'm working off and I don't have my notes in front of me.
Yeah, Mr. Chairman, the struck language above is the key.
I see where you're striking that part.
Yeah, and then it says, then what it does, it makes it clear that they can, when reasonably necessary, designate someone from another district. So the prohibition of someone who regularly practices is removed, but they're still allowed to appoint someone whenever necessary who's outside the.
Mr. Chair, if I might give an example. I tried a case in Fauquier County where Fred Swirsky actually sat and heard the case. And you know, they didn't tell me, but it may have well been since I was in the legislature, they chose to have a retared judge do it who was outside the jurisdiction. And that may be a case where the chief judge in that case decided, look, I'm gonna bring in a sub-judge, in that case a retired judge, but have them hear the case. So anyways, we didn't want to take away the right for them to do that, but we just didn't want to have what is in effect a ban right now in having somebody with a local practice be named as a substitute judge.
I see, so that's like the Arlington situation where,
Exactly.
where Judge Newman says anybody I appoint can't practice at all in Arlington.
Exactly.
Right, I got it, okay.
And Mr. Chairman, he's actually following the law in doing that, because wherever possible, they're required to select somebody who does not appear in front of that court. This is changing that.
Right.
And this is actually a suggestion by, well, anyways, I can't remember who suggested it, but it was somebody smart.
Right, okay, I got it.
Is that correct?
Yeah,
Yeah.
you can do it. Yes, Delegate Bell.
I'm reading it, it appears to do more than just make it permissive, it actually flips the default, doesn't it?
It flips the presumption, Mr. Chairman, and there's no prohibition, but when reasonably necessary, they may designate someone from outside that district.
Could I ask the civil chair a question, Mr. Chair?
Yes, Delegate Bell.
I'd ask you, did you consider just saying it's possible rather than, this goes from you can't do it past you may do it to you should do it? I mean,
Yes, so, Mr. Chairman, what I would say is, right now, you have that language that they, wherever possible, they have to get someone who doesn't practice there. So we just struck that, so that's not an issue. That, you could just have a period there and just say, then they can appoint whoever they want to do. And if you did that, you would then strike the next sentence as well. Instead, to make it clear that we weren't also removing their ability to appoint someone else if need be, we picked up the one reasonably necessary and then gave them the current authority they have. So the authority they have right now, a judge can appoint someone who, one, doesn't practice in the court, and where reasonably available, someone from outside, from a different circuit. So what we did here is said we're taking away that prohibition if someone doesn't appear in the court, but leaving their ability, when necessary, to appoint someone from else within the Commonwealth. I don't think we viewed it as super complicated.
Right, I think there's been more discussion, and frankly, we put thought into it, and I think it should make sense, that we shouldn't have had this in the statute to begin with.
Mr. Chair,
Delegate Bell.
I don't have real strong feelings, but we're now making it a preference for someone that practices in the circuit. Yeah, it says when reasonably necessary, you may designate a substitute judge from another district. So you can only do that when it's reasonably necessary.
Well, Mr. Chairman, I would point out there's two issues in here. One is a lawyer who regularly practices in the court, which has nothing to do with what district they live in. That's just the court they practice, and you can practice in 50 districts. The other issue is appointing someone from a different district. So what this says is there is no prohibition now at all for regularly practices. It does have a presumption that you will live in the district in which you appear, which has always been the presumption. That you will live in the district, you just won't practice in the court. This keeps that presumption, but just makes it clear that you can, when necessary, appoint someone who lives in a different district. I don't think it actually shifts the latter presumption. It shifts the former presumption about not being able to appear in that court.
I agree with Bell, but I don't care.
I agree with Bill, and I don't care either.
Y'all are both wrong, and I don't care either.
All righty. Any questions, members? Yep. Delegate Hope.
This is one of the reasons why I voted against it. I thought that the language that you're striking, you should give the chief judge the discretion to appoint to whomever they want. And so change it to may, and just say to select a substitute judge who select a substitute judge who regularly practices in the court, requiring a substitute. So you make it strictly permissive, so you open it up to not they shall, but they may. I think that's what you want to do, but I don't want to take it away from them.
Well, and if I might respond,
Senator?
I think that's exactly what the next sentence says. It says, when reasonably necessary, they may designate a sub-judge from another district. That's exactly what the next sentence is intended to say. Look, the whole point is right now there's a prohibition in the statute saying you can't appoint a sub-judge that practices in that court. That makes no sense. I mean, is anyone going to try and justify that? No. So we're kind of playing word games here. It just...
What if, let me ask you this, what if you didn't have when reasonably necessary? Would that make sense?
That's fine.
Because I think what Delegate Bell's saying is when you put when reasonably necessary, you end up saying
No,
that
Mr.
you
Chairman,
have to make a finding of reasonably necessary to.
just to get someone from outside the district. There's two different issues in the statute. One is someone who regularly practices, the other is someone who lives in a different district. The presumption should be that you'll pick someone from within the district. The presumption should be that you would pick someone who's eligible to actually hold that seat. Like, the presumption is that a regular judge actually lives in the district in which they sit. So, the presumption, I think he is doing the absolute right thing by both allowing someone who practices in the court, that's issue number one, and issue number two, creating a presumption that citizens will appear before someone who actually lives in their district. Now, when necessary, they can go outside of the ladder, but the presumption should be that.
The chair's just walked away, so I'm not quite sure procedurally what I'm doing.
But we have the subcommittee hearing all this, recommend reporting on a 7-2 vote, and I have so moved and will move again.
Okay. Second. The motion has been made and seconded, and I'm just stalling until the chair gets back. Okay, motion's made and seconded to report the bill.
As is.
As is.
Okay. All right, so the motion, is there a second? Charnel, did you have a question?
No, I did not. Thank you.
All right, all those who want to vote in this bill indicate your vote on electronic voting board. Okay, close the roll. Report 16 to 5. Is that a 5? Yeah, 16 to 5. Thank you, Senator.
Mr. Chairman, I think that's our last bill.
All right, now we have a stack of bills that are contested, and I kind of need to get. Yeah, we need the bills. We have copies of the bills yet? Okay, why don't we pass those out? We'll take a couple minute break here and I'll pass those bills out.
Mr. Chair, one of them is easy. Whenever you're ready. That's prices. Mr. Chair.
Yes, Delegate Bell.
This one it's contested, but there's nothing in the language that we need to go over. This is the switchblade bill, Senator Reeves, 1347.
Okay, drawing your attention to Senator Reeves, 1347.
Mr. Chairman, I think the House put a substitute on the bill. I don't know if we need to accept that substitute now and make mine exactly like Delegate Ware's bill.
Mr. Chair, I would move the amendment
Okay, what's the amendment?
to conform.
To conform it to what?
1432, the Delegate Ware's bill.
Right, so we're conforming it now to Delegate Ware's bill.
And then
It's moved and seconded. All those want to do that, say aye. Aye. All opposed? Okay, that's none.
Mr. Chair, a simple bill, it just takes out switchblade life out of that code section 182311. You guys refer this bill vote.
All right, Mr. Chair, this reported out of this committee 13-7. I'll report the no votes so they can be consistent. Everybody trying to keep your votes consistent. The no votes last time with the Ware bill were Albo, Watts, Herring, Mullen, Toscano, Hope, and Krizet. Party line. Party line. All right, Mr. Chair, it wasn't unanimous, but it was the recommendation of the Criminal Laws Subcommittee to report with the amendment 6-4, and I so move.
Okay, moved and seconded to report. All those want to vote in this bill indicate your vote on electronic voting board. Thank you. Okay, close the roll, reports 12 to 8. It went back 10 to 8. It was 12 and I'll check that for No, it's like CPS classes.
Thank you, Mr. Chairman.
Okay, thank you, Senator. All right,
Chair,
Delegate Bell.
we have nothing else that's easy.
Okay,
We can take up the Senate Bill 861, he's here.
okay, Senate Bill 861.
Chair, the senator is here. Chair, this reported out, looks, it was 6-4 report, and someone else will have to move when we get to that step, because I was the one.
Okay, so Senator, why don't you just start from the beginning and tell us what's the problem with the law, what you're trying to do?
So there are two different kinds of protective orders. Preliminary protective orders. We're not talking about EPOs, we're talking about PPOs. Protective orders involving kids and protective orders involving adults. Protective orders involving kids, I think I have this right. One of them, the person has to provide an affidavit. The other one, you either have to do an affidavit or you can do oral testimony to a judge. A Fairfax County Circuit Court judge pointed out to me that about 3 or 4 years ago, all the protective orders, every single one of them started coming up with no affidavit attached. Which meant that if you're accused of violating a protective order, you have no idea what you're being accused of when the thing is served on you before your 14-day hearing. And to me, that's kind of screwy, because I don't know how you're supposed to prepare for your hearing if you have no idea what the allegations are against you. And all this bill basically does is says that you have to have the affidavit. So in order to do a protective order, you have to have the affidavit. They staple the orders delivered to you so you know what you're being accused of before you come to court. There's some concern that with some people who are not native English speakers, the court system was a little slow to turn the affidavits around in terms of translating them, and so when they wouldn't turn them around on the day they were in court, and so they'd have to come back the next day, and then people weren't coming back to sign their affidavits the next day, so they were losing protective orders that otherwise would be issued. From my point of view, my local government, where I'm from, ought to just fund that interpreter. They ought to pay for that service to make sure those people get proper service in the court system instead of having bad law across the entire state. But I think if you are served with a protective order, that you ought to be able to know what you're being accused of, so that you don't have to come to the hearing, find out then have to get a continuance, wait another 2 or 3 weeks, be out of your house, be away from your kids, lose your gun. You lose all kinds of rights with a protective order when it's served on you, and I think you have a right to a hearing on it immediately. So if you're falsely accused, wrongly accused, or if there's no merit to it, you can vindicate yourself and be prepared for it at that first hearing. And so I'm just trying to make the two the same.
Okay, so we got Kilgore, then Lupasi.
Yeah, this is probably just a statement, but my concern with this is that, you got busy courts, and if there's a presentation without an affidavit, then a judge is going to have to sit there and make a summary of the allegations made in the findings, and then that judge may be more apt not to give. There may be a possibility that there's less of these protections given in these ex parte orders. I'm not sure that we need to be doing this. This is going to take a lot of time, and it's going to take a lot of court time, and there may be, like I said, there may be a situation where it may not exactly do what you want it to do, that is to protect someone from in an ex parte order.
Mr. Chairman,
Okay, Deli Lupasi.
my question is don't you have to swear out an affidavit in order to get one of these?
No, not right now. Right now, you can either swear out an affidavit or you can go in front of the judge and tell them what you have to say.
All right, so can I speak to it?
Yes, Deli Lupasi.
Okay, my thing is, it seems, I agree with what Senator Servell is saying, that there should be some kind of notice to you of what the conduct is. I just don't agree that a judge ought to be writing down it. I think you should be required to fill out an affidavit, just like if you're taking down a salt warrant or whatever. You got to swear by affidavit what it is, and write it out and sign your name to it. Put them under oath. So, because it's exactly what he's saying, that there's no court order there when they do these things orally. I mean, he's right. I just don't agree with. I'm not sure I agree with how he's resolving it.
Okay, Delegate Herring.
Well, and I first of all, I did support the measure, and I told the senator that I'm going to have to oppose it. And looking at the petition, there is a line, and that may be what Delegate Lupasi is talking about. It says, this number 2, the respondent is committing or within a reasonable time has committed the following acts of family abuse. There's a box where it says see accompanying affidavit. Then there's another box with a dotted line for somebody to fill in and say, you know, for example, shoved, pushed, and not petitioner to the ground. But there is something there. So I just wanted to bring that to the committee's attention since I had it on as someone sent it to me because I shared the concern, but there is some sort of notice. Thank you.
All righty, anybody else in the committee? Anybody in the audience want to speak for or against the bill? Okay.
I already expressed my opposition to this bill in the subcommittee. I just want to clarify that the Child Protective Order is in no way similar to the Preliminary Protective Order for family abuse. These are two different processes.
Good afternoon, Mr. Chair. Lauren Schmidt on behalf of the Virginia Sexual and Domestic Violence Action Alliance, and we also oppose this bill. Thank you.
Good evening, Mr. Chairman. David Ledbetter, Commonwealth Attorney for the City of Waynesboro. I'm here on behalf of the Virginia Association of Commonwealth Attorneys. We don't oppose the notion of an individual that is facing a protective order. They know what the allegation is against him. Our opposition to the bill is really with the judicial summaries. We have an issue with that, is where you have an individual that may go through an interpreter, that then the judge makes a summary, and then that summary then becomes evidence against them in the subsequent criminal hearing. So we would ask that it either be by affidavit, or if you're going to say the judicial summaries are acceptable, we make those where they are not admissible as evidence in a subsequent criminal trial.
Okay, so can you get with him and make some amendments? Okay, Delegate Gilbert. Delegate Gilbert.
No, I withdraw.
Okay, Delegate Kilgore.
I have a motion.
Okay,
Motion to lay this bill on the table.
Okay, it's moved and seconded to table, not debatable. All those who want to table the bill, say aye. Aye. All opposed? No. Okay, all who want to table, raise your hand. Okay, all who don't want to table, raise your hand.
That's a weird.
12, 8 the table, right? Okay, lay to the table.
I'll be back.
Okay, so the next bill.
I'm clear, I'm good.
Yeah, can we get Stuart and Chapin here? Okay. We're going to be at ease while we get Stuart and Chapin, because I don't want to be... No, I think it's last two. Okay, we're at ease right now. right now, so. But Chafins is just like one person. Jason only has